Hey guys, Moms Against Medical Bullying. It's a beautiful day here this Saturday, and I just wanted to share this court case with you guys. It's actually a mask case, and I wanted to take a look at with you what their spin was, what their argument was here in this case. So this is from March 19th, 2021, Supreme Court of Alabama, and I guess you would call it the plaintiffs, Barry Munza, Larry Lewis, and Debbie Mathis versus KIV in her official capacity as governor of the state of Alabama, Scott Harris in his official capacity as state health officer of Alabama, and the Alabama State Board of Health. And this is an appeal from Montgomery Circuit Court. So meaning that when you want to do an appeal, when the circuit court doesn't rule in the way you think, you do an appeal to the Supreme Court of your state. So it says here, Barry Munza, Larry Lewis, and Debbie Mathis, the plaintiffs, appeal from the Montgomery Circuit Court's order dismissing their complaint, seeking certain injunctive relief, and challenging a proclamation issued by Governor KIV requiring the use of facial coverings in certain circumstances as outlined in an order issued by Dr. Scott Harris, the state health officer, to slow the spread of blank blank. I won't even say the word, guys. So, facts and procedural history. I don't really want to read this because this pays homage to the CDC and, all those things, blah, 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 all their justifications as to why they want to do this to us. All right. So I'm going to scroll down. I think the Alabama's executive order is interesting. It's a bit better than my state, actually, because my state turned to saying that even when you work out, you need to wear a mask. How much more evil can you get? I don't know. Hopefully this doesn't get taken down for saying that, but let's see here. Okay, on July 15, 2020, Governor Ivey issued a proclamation adopting Dr. Harris's order as amended effective July 15, 2020. That, among other things, required a mask or facial covering to be worn in certain circumstances. The amended health order stated the following: facial coverings for individuals effective July 16th at 5 p.m. Each person shall wear a mask or other facial covering that covers his or her nostrils and mouth at all times when within 6 feet of a person from another household in any of the following places: an indoor space open to the general public, a vehicle operated by a transportation service, or an outdoor public space where 10 or more people are gathered. But this facial covering requirement is subject to the following exceptions. Exceptions for practical necessity. The facial covering requirement does not apply to any person 6 years of age or younger, any person with a medical condition or disability that prevents him or her from wearing a facial covering. And by the way, guys, in none of these orders, not in this one and not in my state, they do not put religious exemption, which is wrong. Any person while consuming food or drink, any person who is obtaining a service, medical or dental, that requires removal of face covering, any person who is required to remove face covering to confirm identity. Exceptions for exercise. The facial covering requirement does not apply to any person who is actively engaged in exercise in a gym or other athletic facility if she maintains 6 feet. Participating in athletic activities. Any person who is in a swimming pool or lake. Exceptions for effective communication. It says any person who is seeking to communicate with another person where the ability to see the person's mouth is essential. Any person speaking for broadcasts. Exceptions to facilitate constitutionally protected activity. Any person who is voting. Any person who cannot wear a face covering because he or she is actively providing or obtaining access to religious worship through wearing. Okay, so, they put it in there, but only in the setting of a church, I suppose. Exceptions for essential job functions. All right. says Governor Ivey has extended the facial covering requirement several times since issuing the July 15 proclamation adopting the amended health order, which is the same thing that's been going on in Kentucky. On July 24, 2020, the plaintiffs sued Governor Ivey and Dr. Harris in their official capacities and the Alabama State Board of Health, seeking a temporary restraining order and injunctive relief regarding the July 15 proclamation adopting the amended health order mandating the use of face coverings. On July 26, 2020, the trial court entered an order denying the plaintiffs' request for a temporary restraining order, stating that the plaintiffs had failed to demonstrate that they would be irreparably harmed without the issuance of a temporary restraining order. On July 27, 2020, the defendants moved the trial court to dismiss the plaintiffs' action, seeking injunctive relief on basis that the trial court lacks subject matter jurisdiction, and on the basis that the plaintiffs had failed to state a claim upon which relief can be granted. In the alternative, the defendants moved for summary judgment. The defendants specifically argued, among other things, that the plaintiffs lacked standing because they failed to plead any particular injury caused by the facial covering requirement, and that the plaintiffs' claims for injunctive relief against the defendants are barred by the doctrine of sovereign immunity. You know, Carl Miller goes over that immunity thing that they claim they have. On August 7, 2020, the plaintiffs filed a response in opposition to the motion to dismiss, or an alternative for a summary judgment. Following a hearing, the trial on August 11, 2020 entered an order denying the plaintiffs' request for a preliminary injunction and granting the defendants' motion to dismiss. You know, guys, if they can motion to dismiss, why can't we motion to dismiss, right? When the state wants to take someone to court over something, why can't we can motion to dismiss too, just like they did. Oops, why is my phone doing that? No. Okay, let's see here. We'll move on to discussion. The defendants have asserted that I said that already. Plaintiffs lack standing to challenge Governor Ivey's July 15th proclamation adopting the amended health order that required masks or facial coverings to be worn in certain circumstances. Public law actions involve constitutional or other challenges to the actions of officials or administrative agencies. A party establishes standing to bring a challenge in a public law case when it demonstrates the existence of an actual, concrete, and particularized injury in fact, an invasion of a legally protected interest, a causal connection between the injury and the conduct complained of, and a likelihood that the injury will be redressed by favorable decision. The court has explained the following with regard to the injury element of standing. Injury will not be presumed. It must be shown. A party's injury must be tangible, and a party must have a concrete stake in the outcome of the court's decision. The plaintiff must allege specific concrete facts demonstrating that the challenged practices harm them and that personally would benefit in a tangible way from the court's intervention. At a minimum, they must show that they personally have suffered some actual or threatened injury as a result of purportedly illegal conduct. The plaintiffs allege the following in their complaint. The governor and the health officer, so this is what they said. Throughout the past 4 months have issued various proclamations and orders restricting the freedom of the citizens of Alabama in response to what is known as blank blank. On July 15, 2020, the governor issued a proclamation incorporating an order also issued on July 15, 2020 of the state health officer, which mandated, among other things, that each person wear a mask or other facial covering at all times when within 6 feet of a person from another household, with some exceptions. Said proclamation provided threat of fine and incarceration for violation of the proclamation. The plaintiffs are directly affected by the proclamation order as they are located within the boundaries of the state of Alabama and during times interface with the public at distances of less than 6 feet. Plaintiff Munza is a retired sheriff's deputy and interfaces with the general public in his normal daily life, oftentimes within 6 feet of another individual. Plaintiff Lewis is a retired sheriff deputy and interfaces with general public in his normal daily life, oftentimes within 6 feet of another individual. Plaintiff Mathis is a real estate agent who interfaces with the general public in her personal and professional life, oftentimes within 6 feet of another individual. All other individuals currently located in Alabama are similarly situated and affected by the proclamation and order. Said proclamation and order are illegal. Said proclamation and order have been illegally adopted against well-recognized procedure for adopting the promulgating health rules and regulations. Said proclamation and order are unenforceable and nothing more than an expression emanating from the governor and health officer. The plaintiffs have failed to allege any specific concrete facts demonstrating that they have suffered an actual injury as a result of the July 15 proclamation, adopting the amended health order that required masks or facial coverings to be worn within 6 feet of a person from another household. Rather, the plaintiffs broadly asserted that they were directly affected by the facial covering requirement because they live in Alabama and that during certain times they interface with the public at distances of less than 6 feet. Absent from the plaintiffs' allegations is any description of an actual concrete and particularized injury in fact, proximately caused by the facial covering requirement. The plaintiffs further allege that the July 15 proclamation adopting the amended health order requiring the use of masks or facial coverings was illegal and unenforceable. Those assertions are wholly conclusory in nature and fail to demonstrate an injury in fact, because an individual's belief that a law is invalid or unenforceable is not the kind of actual concrete and particularized injury in fact that supports an individual's standing to sue. Let's see here. And that was the case they used to say that. Relying upon Parker versus Judicial Inquiry Commission of Alabama, not reported in the federal supplement, the plaintiffs argue that they have satisfied the injury in fact requirement for standing because they say they are threatened with imminent injury in the form of a fine or incarceration. So this was their main argument. It seems like that there was an imminent threat to them, imminent injury, which was in the form of fine or incarceration for those instances when they interface within 6 feet of persons outside their households without wearing a mask or facial covering. In Parker, which is the case cited above, then Justice Parker brought a pre-enforcement action with challenging the constitutionality of several Alabama canons of judicial ethics, as well as Code 159 of the Alabama Constitution of 1901, alleging that the challenged judicial canons violated his First Amendment right to freedom of speech by restricting the ability of judges to speak out on certain issues, and that 159 violated his 14th Amendment right to due process by providing for suspension of judges who have complaints filed by the Alabama Judicial Inquiry Commission pending against them. The federal district court determined that Justice Parker had standing to bring the action, stating that a plaintiff satisfies the injury in fact requirement where he alleges an intention to engage in a course of conduct arguably affected with a constitutional interest, but prescribed by a statute, and there exists a credible threat of prosecution thereunder. So this judge said that this rule or whatever violated his First Amendment. See, I wonder why these three people, why didn't they go further in it? Like, they could have said that it violates their religious liberties to wear a mask. But I guess, let's see here. The federal district court explained that Justice Parker satisfied those requirements because he had alleged that he intended to engage in political speech that is arguably prescribed by the judicial canons at issue and might result in his automatic suspension. There existed a credible threat of prosecution. They had already once been subjected to investigation, blah, blah, blah. Okay. So the plaintiff's allegations of an imminent threat of enforcement of the July 15 proclamation adopting the amended health order against them differ substantially from those in Parker. The plaintiffs have failed to allege any credible risk of enforcement that would give rise to standing that would support a pre-enforcement action. So maybe it's because they didn't actually state that they don't wear a mask due to religious reasons. Maybe they just needed more information, it seems like. The plaintiffs rely upon Babbitt Supra for the proposition that a plaintiff should not be required to await and undergo criminal prosecution as the sole means of seeking relief, right? Like, that's true. Because they're basically saying, like, oh, you have to experience the injury in order to say you want relief from it or restraining order from it. But they're saying that they should not be required to await or undergo criminal prosecution as the sole means of seeking relief. Although that is true, Babbitt also requires that a plaintiff allege that either he was threatened with prosecution is likely, or there is a credible threat of prosecution. Okay, well, there is. I don't get what the defense is. I don't think the defense is doing a very good job. The plaintiffs have alleged that no facts that would satisfy those requirements. The plaintiff's complaint does not contain a single allegation that any of the plaintiffs have been specifically threatened with enforcement of fine or incarceration. That makes no sense, because the threat of fine or incarceration is directly said to all people who live in that state who don't follow the proclamation. So I don't think the defense is right on either. Instead, all the plaintiffs alleged was that the July 15 proclamation provided threat of fine and incarceration, that the plaintiffs are directly affected by the proclamation order as they are located within the boundaries of the state of Alabama. Although the plaintiffs now argue that they are at risk of incarceration at times when they are in public places, their complaint fails to even state that they have refused to wear masks or facial coverings in public, such that they could be subject to enforcement action. Okay, so basically, this is silly. So because they didn't state that they don't wear facial coverings, you can't let them assume that. Further, the plaintiff's complaint contains no allegations about how the facial covering requirement is being enforced, to the extent that the requirement is being enforced at all. All right. Let's see. I don't want to read all that. So yeah, basically, said we conclude that the plaintiffs lack standing. And I guess, let's see here. To bring their complaint seeking injunctive relief regarding the July 15th proclamation. Because we have determined the plaintiffs lack standing, we pretermine discussion of the remaining issues present by the parties. So yeah, that was their arguments of imminent threat of incarceration. But I guess they didn't put enough details. They weren't maybe specific enough. So I'm confused about this, because I'm not sure if this already went through the Supreme Court of Alabama. And then they ruled that in the Supreme Court. Maybe somebody else knows, who knows how to read these documents better. Or is this going to be heard in the Supreme Court, and this was the appeal from the Circuit Court? I'm not quite sure. But I just wanted to share this with you guys, just to share the angle of their argument here.